Thank you for joining us. This is the first webinar in our Special Asset Summer School series. This session will cover the topic of special topics in judgment enforcement and collection. I'm Haley Upton Cook, Marketing Coordinator of Events and Proposals here at Ward & Smith, and I'll be your moderator this afternoon. We have set this webinar for about 1 hour. If you have any issues with your video or sound quality during the presentation, please reach out via the Zoom chat feature, which is going to be located on the black bar at either the bottom or the top of your screen, and I'll troubleshoot with you. Our speakers today, Tyler and Thomas, are going to be happy to take questions during this webinar. If you have a question, please type it in the Q&A box, and it will be addressed at the conclusion of the presentation. They may choose to answer a few along the way if it's relevant, but we will absolutely get to them at the conclusion of this presentation. Let me introduce our esteemed speakers for this afternoon. Tyler Russell is a business and creditors' rights attorney in our Raleigh office. He began his career in 2010 in the firm's creditors' rights practice group, representing banks and lenders in commercial bankruptcy, collection, and lender liability defense litigation. Tyler's current practice also includes transactional representation of business clients in mergers, acquisitions, and other corporate matters. Thomas is a creditors' rights attorney also in our Raleigh office. Thomas's practice encompasses a wide range of creditors' rights laws and business transactions. His creditors' rights experience includes representation of financial institutions, lenders, community associations, and other creditors in collections and bankruptcy proceedings, as well as navigating commercial loan transactions and workouts. Thomas routinely represents creditors in commercial litigation, in addition to drafting complex loan and settlement documentation. I will now turn the mic over to Tyler. If you're good with that, to get started.
Yeah, thank you, Haley, and hello to everyone who's joined us on the call. Thank you for being here. It's our pleasure to do this, and hopefully the information we'll share today will give some helpful and relevant highlights of judgment enforcement and judgment collection, and that's really the meat and potatoes of what we do in our creditors' rights practice, right? Whether it's judgment collection, workouts, bankruptcy, it's all focused on getting loans back on track, or where that's not possible, finding a way to facilitate collection and recovery and minimize client loss where possible. And so today's conversation is going to focus on the judgment enforcement, judgment collection piece. The large majority of the conversation that we're going to have today is going to focus on what happens once you get a judgment in hand. So we won't talk so much about the lawsuit, litigation, demand, all those types of issues that come before a judgment is entered. We're going to look from the date a judgment is entered forward and talk about some of the options that the bank may have. A lot of this may be information that you've heard before, and if so, hopefully this is a helpful refresher. There should be some new information that we'll share as well, some new tips and techniques that we'll discuss later in the presentation materials. And as Haley suggested, if you have questions, please do enter them into the Q&A feature in the chat box. We will have a chunk of time reserved at the end to try to work through as many of those questions as we can for you. And to the extent we don't get to questions, we'll do our best to follow up with folks offline. And to the extent you have thoughts or questions that come up after the conversation, or you're just more comfortable having a one-on-one conversation with us offline, we're more than happy to schedule times to have telephone conversations, Zoom calls, in-person meetings as well. So again, thank you for taking the time to be here with us. We really appreciate it. And with that, we'll kick it off. So judgment liens, what are they? What do they mean? Obviously, you get a judgment. It's a piece of paper that entitles you to repayment, right? It's a right to repayment, but a judgment in and of itself doesn't get you paid unless the judgment debtor voluntarily agrees to pay you. More often than not, if you've had to spend the time and effort to file a lawsuit and chase someone down, it's because they're not willing or they're not able to voluntarily repay you. And so the first layer of protection for the creditor client is the judgment lien itself. If that judgment debtor owns real estate within the state of North Carolina, that judgment lien automatically attaches as a lien to that debtor's interest in real property in whatever county the judgment has been docketed and indexed in. And so, for instance, we are here in Wake County. If we have a judgment debtor who resides in Wake County and owns 100% of a piece of real estate in their individual name, we get a judgment against that individual in their individual name. The judgment lien is going to automatically attach to that real estate as a lien. Again, that doesn't get you paid, but it expands your repayment and enforcement rights to try to turn that judgment into cash in some way. Important point to note is that the lien only attaches to that judgment debtor's interest in the property. So if there are other owners that own an interest in that property as well, and the judgment debtor and they are not also liable on the judgment's not going to attach to their respective interest in that property. And there are certain types of property interests like tenancy by the entireties and others that may affect whether or not a judgment lien actually attaches to a piece of real property too. Thomas will talk about that some more in a moment. But just important to keep in mind that that judgment lien will automatically attach to real property in the county where the judgment is entered or where it is otherwise transcribed to the extent of the judgment debtor's interest in the real property. Transcribing from county to county is very easy. We can do it once the judgment is entered. We don't have to wait any particular periods of time typically to transcribe that judgment. There are AOC form documents that allow us to do it, and we can transcribe to one additional county or all 100 counties within the state. We typically just transcribe to counties where we know or suspect the debtor may own real property to put it on record there as well, because it's a nominal cost, easy to do, and add some potential rights should the debtor acquire property in those counties down the road as well. Domestication of a judgment is an additional remedy here to try and again get at expanding those judgment liens and judgment lien rights. If the debtor owns real property out of state, we can help to domesticate that judgment to that additional state and get full faith and credit of that judgment in that other state as well, have it recognized and potentially act as a lien on their property in the other states too. And then conversely, if you have an out-of-state judgment and a debtor who owns real estate or other assets here in North Carolina, we can help to domesticate those judgments from that foreign state to North Carolina as well. It's a relatively simple process to domesticate a foreign judgment here in North Carolina. You file a new lawsuit to have that judgment recognized. There are a very limited number of defenses that the judgment debtor can raise to that judgment, assuming that it was final, non-appealable. The court had proper jurisdiction to enter judgment against them in that other state, and a handful of other items like that. And the judgment is essentially recognized and valid when filed here in North Carolina. However, we can't seek to enforce or execute on that judgment until it becomes final and non-appealable here in the state. The only other point that I would mention in connection with judgment liens is the scope. Typically, a judgment in North Carolina is valid for a period of 10 years from the date of its entry. And we use the term renewal often when talking about judgments. It's not actually technically correct, I would say, but we can renew, quote unquote, that judgment for an additional 10-year period if needed by filing a lawsuit towards the end of its lifespan at the appropriate time. And that lawsuit basically just says, High Court, I obtained a judgment less than 10 years ago. It hasn't been paid. Here's some relevant information on that topic and a copy of the judgment as well. And then the court enters an order that recognizes its effect and validity for an additional 10 years going forward. Once you max out that 20-year window, if you haven't collected on the judgment by that point in time or sought to enforce any judgment liens or other rights that you may have under it, the judgment becomes null, void, ineffective, and you may be SOL on collecting at that point in time. And Thomas, I'll kick it over to you.
Yep. Thanks, Tyler. So I'm just going to take over from where Tyler was mentioning about kind of the scope of the judgment being against the ownership interest in real estate in the county where it's filed. As you mentioned, this is something that happens automatically as soon as the judgment is filed in the county, and it becomes final and non-appealable. It becomes a judgment lien on their interest in any kind of property in that county. Not only is it a lien on the property they own, but also lien on property they may inherit or purchase or come to acquire. So again, it's important to get judgments early, to get them whenever they're needed, because you never know when somebody's going to come into an inheritance. They're going to acquire some property. They're seeking to purchase property. And so we want to make sure that judgment's in place before those things happen. And if we do find out that some of those things happen and maybe they're in a different county, take those efforts to get that judgment transcribed to those counties to make sure that we're doing what we can to make sure that judgment captures as wide of a net of property that we can. The goal is, if they ever want to sell property, if they ever want to take out a loan, that our judgment's going to pop up when a bank officer is looking for it, when the title company is looking at the record, the closing attorney, and that's the best and easiest way to get paid, is just making sure that judgment lien's in place in the first place. But again, the judgment is only limited to who it's filed against, and Tyler did touch on kind of the marital interest and the tenancy by the entireties, which is something we see quite often. Just because you get a judgment against husband and not against wife, if they have a marital home that they share an ownership in, that judgment will not attach to that property. In order to get at marital property, the judgment has to be against both spouses together. So it's always good to have both of them in the lawsuit if we have a basis for it, through the guarantees under the loan or whatnot. But that gives you a much wider net of recovery as well, because then you can go after the marital property they own together. But you can also go after the property they own separate. Maybe husband has a piece of property that he owned before his marriage somewhere else. You can still go after those things. The judgment still attaches those properties. And so we got to pay attention closely to what properties are held by the debtors and how they're held. Marital properties, one, the judgment or the deeds, when they acquire title to property, will usually mention that they are spouses to give some indication that the property is held in that manner. They can also say that property is held by tenancy by the entireties or joint with a right of survivorship between parties. So you can still hold a property with another person that's not a spouse. You can have it with your son or your daughter and still put those protections in place. So it's going to matter how that deed's been drafted and taking a close look at it to make sure we understand how the ownership is and whether or not the judgment's going to attach to it at the end of the day. Again, LLCs, corporate assets, something different. Maybe the debtor has an LLC or a business and they put their property in its name. Maybe they have a trust that they keep their property titled in. If your judgment's not against those businesses, and if it's not against the trust, again, it's not going to attach to those properties. Sometimes you run into savvy debtors that know how to get around the system a little bit more and do a little bit of estate planning, and will make sure their property is titled in different places to try to get around these issues. And that's some stuff that we can kind of help navigate when the time comes. Moving on to the next is the beginning of the execution process. When we talk about exemptions, I think there was one more slide prior to that one, but the exemption process is the official start of execution. So before we can go after them and start taking property, levying on things and selling things, we got to give individual judgment debtors a chance to claim their statutory exemptions. Under North Carolina law, under the Constitution here, there are certain amounts of equity in their personal and real estate property that they're entitled to claim as exempt that our judgment will not attach to, and things that we cannot execute on. Importantly, number one, it does not apply to folks that are not residents of the state. It only applies to those that call North Carolina home. Now, you can own property in multiple states, but what it comes down to is where their actual residence is. Not always easy to figure out, but more often than not, we can make that decision early on to figure it out, whether or not we have to serve them with a notice of right to begin that process or skip right to execution. It also doesn't apply to corporate businesses, LLCs, and those sorts of things. It only applies to individual debtors that are residents. So it is limited in scope. If it's a business that the judgment's against, we can immediately proceed to execution, skip this process. But if it's an individual, little more finesse needs to be taken here. It's a statutory process. It's very straightforward and form driven. It starts by sending out a notice to the judgment debtors. It's going to be served by the sheriff or certified mail in the same manner as we would a complaint. It essentially gives them a heads up that they're entitled to these exemptions and gives them a very short window of 20 days to claim them. They can file a short motion and listing out all the property they feel is exempt. And then once we're served with that, we have another very short 10-day window to respond and object to anything that we think exceeds the statutory limitations. All states have different statutory thresholds for what can be an exempt and what's not. We kind of fall a little bit in the middle here in North Carolina. We're not the most generous, but we're not the most strict either. People can exempt up to $35,000 in the equity in their home. If it's held jointly with two debtors, that can add up to $70,000 that comes out of the equity that is untouchable. If they have a vehicle, they can get up to $3,500 on that. Usually if they have a lien on a vehicle coupled with an exemption for this equity, it makes it really hard to go after it. But if they have more than one vehicle, they're limited to $3,500 in their vehicles. They do have a wild card exemption of $5,000 they can use to apply here and there. But it's only available to debtors if they haven't used up their homestead exemption. Those are the main ones. Other than that, they can exempt up to $25,000 in college savings funds, but then they can completely exempt retirement accounts, IRAs, and those sorts of things, alimony, and other special cases. But again, this process is a little bit more of an art than a science. And once we get a motion from them about what they're trying to claim as exempt, we can sit down and go through it, figure out what they are doing that may be exceeding, and then determine whether or not it makes sense to object, because it does require a hearing. And if they're maybe exceeding an exemption here or there, but it's not something that we'd be able to get at anyway or cost effectively go after, may not make sense. So it's something that we'll kind of work together on, but it does have a short window to be aware of. And so after the exemption process is complete, then we can finally move on to the actual execution, which Tyler will take over from there.
All right, thank you. Yeah, everybody's favorite topic, judgment exemptions. So the execution process is also just very statutorily driven process, right? The statutes lay out when you can do it, how you can do it, what you can go after, how you go about trying to recover from these assets. If assets can be sold, how, when, and where they're sold to reduce the judgment to cash. And so judgment execution is not going to be pursued until that judgment is final and non-appealable. Judgments in North Carolina typically become final and non-appealable 30 days after the date of their entry, unless an appeal is filed. If an appeal is filed, that can drag that process out. Typically, though, if an appeal is filed, there's some sort of bond requirement that must be posted in order to stay execution pending appeal. So there are a little bit of there are some legal protections for judgment creditors when a debtor tries to appeal a judgment and continue to drag that out. If once we get past those hurdles and we get to the point where we can pursue judgment execution, we have a couple of options. One is a writ of execution, which allows us to go out and try to recover from any assets of the debtor that may be available and non-exempt. Two is a writ of possession, which we really use in secured loan transactions to go after the collateral itself, which the court may have awarded us a right to possession of in the course of the lawsuit. For writs of execution, we fill out the AOC form that is required to be used in the state of North Carolina. We have that issued by the clerk of court. We have it sent to the sheriff or sheriffs of the county or counties where the judgment debtor resides and maintains assets. We can issue multiple writs to multiple counties at the same time. We can issue one writ now to County A and one writ later to County B. There's flexibility on that side of things. The sheriff will go out and serve the writ of execution on the judgment debtor. The sheriff will do an asset investigation, and the sheriff will try to find property that the judgment debtor owns, which may be subject to execution and not otherwise be exempt from recovery. Our preference when we do pursue writs of execution is to work with our clients to find any relevant information we can from the loan file or otherwise. Typically, if you have been lending money to these folks, you may have a personal financial statement, hopefully one that's recent, which discloses some assets, whether it's vacation homes, cars, stocks and bonds, bank accounts, whatever they may be, but something we can pull information from and share with the sheriff's department in order to try and narrow their search and help them put their hands on assets and information a little more quickly. It's a little bit of a help me help you type of situation when dealing with the sheriff, because they have a lot of these types of requests on their plate every day. And so the more targeted information we can get them, the better outcome we typically see. Once the sheriff conducts that investigation, if they find assets, they'll let us know. They'll typically have conversations with the judgment debtor as well and encourage them to make a voluntary payment on the judgment. If there are assets or if there's property that's subject to levy and we choose to go after it, we make a business decision that it's worth it to spend the additional time and money trying to seize it and sell it in whole or partial satisfaction of the judgment. There may be some upfront levy fees to share with the sheriff, and we can then send the sheriff out to go grab it. So for instance, if it's a vehicle, the sheriff can go seize the vehicle, take it off site and store it pending sale, public auction. If it's real estate, the sheriff can levy on the real estate through a process. We can do title work and things like that to help speed things up and make the sale process cleaner and easier and hopefully maximize value for the sheriff. If it's stocks and bonds, there may be a process for pursuing those. Bank accounts may be a process for pursuing those, although we'll talk about that in more detail as it relates to individual bank accounts later in the presentation. And if the sheriff can sell it, and there's a buyer out there who's interested in the property and shows up to the sale and pays for the asset, that money flows through the sheriff's accounts over to the clerk's accounts, gets credited against the judgment, and then ultimately gets released back to us at some point down the road. So it's a fairly streamlined process. It does take time. Writs of execution are valid for 90 days from the date of their issuance. So the sheriff has up to 90 days to serve it, to look for assets, and if assets are there, to levy on them before the writ expires. If the writ expires, we can always reissue a new writ and jump right back into the fray. Writs of possession, to touch on those briefly as well. Again, this is typically going to be used to recover a specific piece of property, which more often than not served as collateral for your loan. And when we file suit, we'll ask for a money judgment. We'll also ask for an order of possession for that collateral to the extent we haven't recovered it yet. And this writ of possession is the post-judgment remedy for going and getting our hands on that collateral or other property that we have a right to. It goes again to the sheriff. The sheriff will go out and serve the document on the judgment debtor and try to find the property If the sheriff can locate it, the sheriff can take it and remove it and return it to the possession of the bank for further liquidation or distribution. If if the property can be located, but it's under lock and key, the writ of possession doesn't help us navigate the issue of getting the property back right away, because the sheriffs are not allowed to breach the peace in the service of a writ of possession. Meaning, if the judgment debtor tells them to leave their property, or if a car is locked in a garage, or if a tractor is locked behind a fence on a farm, they're not going to be able to open those gates without consent and go in and get the property. And we may have to go back to the drawing board and look at some additional options and additional steps to force the issue there. And writs of possession also have relatively limited value if we don't know where the property is, or it's no longer in the debtor's possession, because it's going to be issued in the name of against that particular judgment debtor. And if the debtor doesn't have possession, there's really no remedy for enforcing that writ at the end of the day. But we do have other options, which again we'll discuss some more of later in the presentation. And we mentioned a little bit about the leveraging real estate piece. If the debtor has real estate, the real estate is non-exempt, or there's sufficient equity in the property over and above their statutory exemptions, if any. We can use these the judgment lien and the judgment execution process to tee up and force a sale of that real estate in many instances. And sometimes just the threat of doing so or starting the process helps as a pressure point and a settlement lever with judgment debtors who don't want to lose the property, want to retain it, and will come to the table when that happens and try to negotiate some sort of workout and resolution there. Next slide.
All right, so supplemental proceedings. In short, what we're talking about is the whole discovery process in a different forum. So when you do discovery, you are preparing for a lawsuit or preparing for a hearing, trying to obtain the judgment. And so your scope and ability to get information is limited to the facts of the complaint. So looking at the liability, looking at the loan documents, the obligation, the amount owing, and those sorts of things. We can't get away with sitting down a debtor in a deposition and asking about their assets if they're not pertinent to the actual loan obligation that we're talking about. That's going to get objected to, and it's not proper in that forum. But after a judgment, the case is over, and so the court allows us to go through the same process, but it's a much more wide open process. It's more of a fishing expedition, and we can ask pretty much anything we want relating to their assets, their liabilities, and anything under the sun they may have that may be applied to our judgment in satisfaction of the amount that's on it. So we have a lot of different tools in that toolbox that we can take advantage of. Obviously the first being written discovery. This is your interrogatories, your request for productions, the same written discovery that we're used to before, or we're essentially asking questions for them to answer under oath. Again, same type of things that we're looking for here for a judgment attached to, that we're going to be asking questions about. Tell me about your bank accounts. What kind of vehicles do you own? What real estate do you own? Do you own anything out of the state? Really honing down on anything that we may have missed. If we think they may have been moving assets around and having trouble finding things, trying to find a way to uncover where those things have gone. The only real limitation that supplemental proceedings have is for each of the different items that we can take advantage of, they have limitations of whether or not we've already issued an execution and it's been returned first. Written discovery is one of those things where we have to be able to tell the court that we did send out the execution, the sheriff did his due diligence and returned the paperwork unserved, and there's still a balance owing. Got to at least check that box before we can jump to supplemental proceedings. Court doesn't want us starting in that forum before moving forward with the execution. But again, it's a broad fishing expedition, so it's definitely got some value to it, especially if we think that there's some pieces of property that are being moved around or concealed that we can't really easily get our hands on. Second is depositions, which is exactly what it sounds like. It's a supplemental proceeding examination under oath in front of a court reporter. We spend the day just grilling them on everything that they may or may not have in their portfolio now, and trying to find those assets. Much more effective than written discovery. We can kind of catch them off guard, maybe get a little more off the cuff answers where they're willing to divulge some more information they wouldn't usually in the written discovery responses. Again, there's that does come with some cost to do that, but if we think that there's actual assets to be grilled on, it's definitely worth it to at least close the loop and make sure that we're doing everything we can to collect on the judgment and not leaving anything out on the table.
Thomas, can I add one additional thought on that too? Those post-judgment supplemental examinations, the depositions he was mentioning, can be very helpful as well if we have reason to believe that the debtor is engaging in fraudulent transfers, which Thomas will talk about in a bit. It's kind of pre-lawsuit, pre-additional lawsuit discovery for us if we can get down and ask them questions about their assets. You know, what did you own in the last X years? When did you sell it? Who did you sell it to? And go from having a hunch that they were engaging in fraudulent transfers to keep us from being able to collect, and sometimes transition that hunch into actual factual usable evidence that we can then help to craft a complaint and pursue whatever additional remedies we may have against them and the transferee of those assets to try and claw them back, or otherwise find a way to leverage repayment from those activities.
No, that's a great point, Tyler. It's really taking advantage of that fishing expedition and using it to our advantage to prepare for litigation where we'd be kind of held out otherwise. So really good point. The third party is holding property of the debtor. This is what we have effectively termed, debtors of the debtor is how it's phrased. But this is saying essentially any property that's held by someone else that belongs to our debtor is subject to our execution as well. I mean, the most common example of this is bank accounts. A bank essentially, when they have money in an account, they're holding that money. It's owed to the debtor, and so this is what allows us to begin to go after bank accounts, which I'm going to discuss in a little more detail. The best way to do that in a few moments here, but it also extends to other property. Maybe somebody owes them money. Maybe there's a promissory note that's held, and someone, a friend, a family member, another business owes them money under that note. We have the ability to go after the debtor of the debtor and kind of collect those amounts to satisfy the judgment. So it's a very niche area to dig into. And again, the depositions, the written discovery is going to help us uncover if there's anything out there to be aware of on this. But that's what really primarily allows us to open the door to go after bank accounts that might be holding funds in their name, which is another great way of getting repaid on the judgment. Contempt proceedings is really, this is what forces the debtor to comply with all these efforts. And there's already a judgment in place. Maybe it's a default judgment. They probably already buried their head in the sand and have not responded to the complaint. They've not been communicating with us. So why are they incentivized to even listen to written discovery or show up at a deposition? It's an issue that we run across quite often. And the answer is contempt proceedings. If they're not listening, if they're not responding, if they're not showing up, we can easily go before a judge and let them know that they're not communicating with us. They're stopping our investigative efforts. And as a result, we can hold them in jail for up to 90 days until they cure the contempt. So if they don't listen, they don't show up, we get an order, we send out the sheriff, he locks them up, puts them in jail. And then when we're ready to depose them, we can have the sheriff drag them back in and depose them right in court, wherever we need to. until we're comfortable that we've got the answers we're looking for. And it really puts the control in our hands of what to do and when they get let free. If we need to have them produce some documents that we've been asking for, if we're looking for bank records and they only give us partial statements, or there's information missing that we think is needed, they've got to provide it. Otherwise, they're subject to going to jail. And that is a real easy way to make sure someone's paying attention to us and not burying their head in sand. Finally, bank accounts, the freeze and seize issue. Notoriously in North Carolina, going after an individual's bank account is very difficult. Courts have never been on the same page on how to do this. Other states, it's a lot more easy. Other states allow garnishment of wages, so it's a lot easier to get at some bank accounts, or at least get regular payments coming in the door. Here in North Carolina, garnishment's not on the table unless you're talking about certain specialized debts like unpaid taxes, student loans, alimony, and support, those sorts of things. So the normal bank loan or a judgment turned into a judgment is not going to satisfy that, and so we can't straight up garnish an account. If we know they have residency in another state, where they might have bank accounts that kind of transfer over state lines. We've had some success working with Virginia, Pennsylvania, Maryland, and other states where they do allow for garnishing of wages. And so it's a little bit tricky to do, but it's potentially on the table to domesticate to a state and then execute there if garnishment is what we're looking for. But if we're just looking to get at a bank account for what's on deposit, we go through the freeze and seize process, which is a two-part process. First, we got to get an order that allows us to freeze the account. So we don't want to put the debtor on notice of what we're doing and give them a chance to pull the assets away and pull the money out of their account. So we will get an ex parte order, which is an order we can get from the judge without notifying the debtor. We don't have to give them service of any kind of motion that's what we're doing. Allows us to do it kind of away from their eyes, so they don't have a chance to pull away that money from the bank account. So we get that order, the sheriff will serve it on the bank, who will then freeze the funds, so nothing comes in, nothing goes out. And then we can turn around and file another motion to force the bank, as a debtor of the debtor, to turn over whatever was held in the account. And that part will require notice to the debtor and a hearing. But normally, if we already know the money's in there, it's up to the debtor to show that it should not be subject to our execution efforts. And so it's limited to them showing that these are exempt funds, or they're not their funds, it's someone else's money. And it puts the burden on them to try to stop it. And if they can't do that, order will get entered, and then the sheriff will serve that on the bank. And then the check will come through for whatever was frozen that the court determines is non-exempt. So it's a bit of a tricky process. It's a little bit cumbersome, but if it's done effectively, you can definitely get at the funds without notifying the debtor. The catch 22 there is you got to know that there's money in the account. So we need to know and tell the court that there's at least $10 in the account before we can even freeze it. And so if you don't go through the supplemental proceeding process, if you're not getting those records to know, you're kind of taking a shot in the dark, freezing an account that you think they may have money in, and then trying to see what comes from it afterwards. But again, if we know they have multiple bank accounts, or we just have a hunch, sometimes we can get lucky with sending out a sheriff with an order and having a blanket levy across multiple banks. We don't need to know exactly which bank to go after or the bank account number. It depends, out of all 100 counties, every sheriff handles it differently. Most will go after corporate businesses without it going through this process, if we're lucky, but some will not. And so most cases, what we're talking about are individuals when we're going after bank accounts, and not necessarily businesses for this process, but it's going to depend a lot on that county, the sheriff, and the court and the judge, and how they typically handle these processes. But lately, it looks like North Carolina is starting to get a little bit more streamlined and consistent across the state, and this seems to be the prevailing way of going about getting banks frozen and turning over those funds. And so the next thing I want to talk about are some other things we've kind of hinted on before, fraudulent transfers and charging orders. Charging orders is a little bit of a creative way to get at some assets that we don't normally think about. What we essentially do is get an order that allows us to get any distributions that the debtor is entitled to from an LLC that they have an economic interest in. So we're not talking about getting an order that allows us to go in, walk in the door and start controlling the business and making decisions. It's very limited in scope. It's only limited to when they receive distributions under the normal course. It's, in my experience, it's a bit of an annoyance factor for a debtor. If you got a savvy debtor, they can find ways to get around the order by taking salary rather than a distribution. And you don't have a right to control that business to change anything. And so you can't really force them to make payments. They can forego receiving payments if they have the control of the business to do that and find ways to get around it. But certainly it creates an annoyance factor. It makes it more difficult for them to run the business with that in place. And creates other penalties if they don't comply that they got to be concerned with. So it's a very simple additional remedy, another tool in the box to go after. If someone's got multiple businesses, it's a lot easier to just get orders against all of them, and it kind of hinders them in running their businesses going forward.
Yeah, and I'll add on the we do see charging orders work. Yeah, maybe kind of like the best case scenario for when they work is when you have a debtor who has an interest in a successful operating business that is structured as a limited liability company, but that debtor maybe is not the one that's running the day to day. If they're not making decisions about when to distribute profits of the company and how to push money out to the investors and other owners and members of that LLC or other economic interest holders of that LLC. They may not have a say in kind of the timing and the structure as to how they receive their money, and may not be able to run that end around on the charging order that Thomas mentioned. Usually that end around we see is going to happen where there's a single member or like a husband and wife owned LLC where they just agree to restructure whatever distributions they were taking on account of their ownership in the form of W-2 salary or some other type of payment that helps them skirt, whether in bad faith or not, the ruling of the charging order. But they're definitely a useful tool, and we definitely recommend pursuing them when appropriate, because it throws that additional wider net out there for potential recovery at the end of the day.
That's right. I mean, at the end of the day, that's what this whole process is. There's a lot of different things we can do and take advantage of. It's a matter of maximizing recovery and putting our hands in as many pots as we can to get paid. Fraudulent transfers, on the other hand, is not necessarily a post-judgment remedy, but really comes down to a whole separate lawsuit that's filed if we have reason to believe that property was transferred or sold as a way of avoiding our judgment lien, a way of avoiding any creditors. And if we're successful in that lawsuit, the recovery is unwinding that transaction, bringing that asset back into the debtor's hands and allowing our judgment to attach to it. And then again, we can proceed with selling it. If it's real estate, title comes back, our judgment is in place, and then we foreclose on it right behind and send the sheriff out to sell it. This process is a little bit trickier because we need to know a little bit more. I mean, Tyler went over it a little bit earlier. You need a little bit more than just a hunch that they were moving property around to get away from our judgment lien. Property is moved all the time for different reasons and different valid reasons. A lot of people will take the approach that as part of estate planning, they're moving things into the trust for their regular estate planning. But the timing being suspicious is always one real big clue. And so the way the statute's written is kind of open-ended and allows for us to not necessarily prove that they actually did something with fraudulent intent, but we can kind of show with some badges of fraud that all these things when taken together show that they were most likely moving things around to get away from us. So in order to prove our claim in that, we need to show that the property or the asset was transferred without receiving some reasonable equivalent in value in exchange. You know, giving property to a child or putting it in someone else's name without receiving payment. That's a pretty big clue that the property's been exchanged without value, and the timing being suspect kind of helps close the loop and show that there is maybe not fraudulent intent there, but they have something to be questioned on and they have something to answer for. So the other part is there's a whole bunch of other badges of fraud, which I mentioned, that kind of show that there's this nexus and this connection between the timing and the situation and their assets that calls everything into question, that really helps move the claim forward. So they look at things like the closeness of the transferee. You know, so where did the asset go? Was it to a family member? Was it to a friend? Did somebody, you know, was it put on the open market and someone bought it for fair market value? You know, right? If they just sold their home while we were suing them and someone paid full market value for it, it's probably not a fraudulent transfer. They just probably moved while the suit was going on, and, you know, coincidentally so. But, you know, if we could show there's a closeness there of where it went, that is an interested party, you know, that helps kind of move things forward. Did they retain possession? Maybe they put title in the name of their minor child, you know, who didn't really intend to give it to them, but it's in their name and they're really controlling it. It's still their house, still their property, still their asset. It's just not theirs in name only. Did they do something to conceal the transaction? Did they take efforts to try to bury it so we couldn't figure out that the asset was moved? You know, it's a lot harder to show this when there's a public record showing deeds have been exchanged and put on the public record. But again, if there's some kind of concealment or things they went end around the bank to get away from notifying what they're doing, that's just another badge. Another real big one is, were they insolvent or threatened with a lawsuit at the time of the transfer? So maybe they had a debt owing to the bank. Maybe they were current and sold their house, and then we immediately sued them after when they fell in default. You know, that does not appear fraudulent. But if we send a demand letter and say, hey, you haven't paid, you're several months in arrears, pay us or we're going to sue you, and now the property gets sold or transferred right after that, again, just raises an eyebrow of the timing. You know, why'd you sell it now before, right as soon as you realize we're getting ready to sue you? These are the actions you took. And another big one is, was it substantially all of their assets? Did the debtor decide at this time to put everything they own into a trust in other people's names? They transfer all their assets away, or is it just one piece of property? You know, if it's one, maybe that doesn't move the needle as much. But if everything they own has gone out the door and now there's nothing left for the judgment to attach to, that, to me at least, smells of a fraudulent transfer. And so the court's going to look at all these things. You know, they don't look at just one thing in a vacuum. They look at everything and just say, well, where does this fall on it? And the beauty in this lawsuit is that the burden really gets put on the debtor to answer for these things. If we can show these badges and list out the things they did that make this smell like a bad transaction, it's up to them to answer to the court why it was not fraudulent in nature and why everything was above board. And, you know, if they can't do that, that's when we get an order entered and unwind things, and we can pick up with our execution efforts from there. And so moving along, I'll let Tyler take on some of the other post and pre-judgment issues that we got to deal with.
Yeah, thank you. So this is the last slide, and I'll go through it quickly so we can reserve as much time for the Q&A. If you've got, I see one question in the, at least one question in the Q&A forum. If you got more, please submit them. So everything we talked about up till this point is, as I said at the start, has been what happens after a judgment gets entered, but we wanted to touch on pre-judgment remedies as well and talk about some of the things that we can do before we obtain a judgment, whether it's before we file a lawsuit or while a lawsuit is pending. but a judgment just hasn't yet been entered to try and protect our rights as well and position ourselves for the best recovery that we can get. And so attachment, claim, and delivery are two things I want to talk about. And what's not on the slide, but also want to mention is offset rights. Attachment is obviously a prejudgment remedy. Attachment allows us to go get a court order at the start of a lawsuit, and we can do it before the lawsuit, immediately before the lawsuit gets filed, or contemporaneously with the filing and service of the lawsuit. And the attachment order essentially hits freeze on everything that the debtor owns. So when we get an order of attachment, it attaches to the order of attachment attaches to all assets owned by the debtor, whether it's real estate, whether it's personal property, whether it's in the debtor's hands or in someone else's hands. That order of attachment, once it is served through the statutory process, essentially prevents the debtor from disposing of anything, and the sheriff will go out and start to gather up property and take it into the sheriff's possession to be stored or held pending resolution of the lawsuit and final ruling and outcome of the claims that are being pursued. And so that preserves the asset, the asset pool or the debtor's estate, so that during the course of the lawsuit, property doesn't disappear, property isn't, if it's fungible like cash, isn't burned through. If there is like equipment, vehicles, things like that, they're not overly used and heavily depreciated during the course of a long lawsuit. Long laundry list of benefits that come from that. To get an order of attachment, we need a bond. Typically, we can get away with the minimum bond via statute, which is $200. Sometimes the clerks will require us to pay a higher bond, sometimes a significantly higher bond, depending on the types of property that the debtor owns, the claims at issue in the case. But generally, that low statutory threshold is all we're asked to pay. Attachment is a little bit of a double-edged sword. It is, you want to make sure you have a good faith basis for asserting it, and you want to make sure that you're comfortable and confident in the claims that you're asserting in the underlying lawsuit, because if that order of attachment is dissolved, or if you lose in the underlying lawsuit, there is exposure liability for the creditor who obtained that order of attachment. And typically those damages, if awarded to the debtor, are offset against the bond. But if the bond amount is not sufficient, there could be additional risk exposure for the creditor as well. I will say it is, at least in my experience, rare for attachment orders to be dissolved, assuming you've gone through the proper motions and you feel comfortable that you have strong claims in the case and that you have a good faith basis for seeking the attachment order. And typically we can seek those attachment orders where we have an out-of-state debtor, a debtor who is moving property out of state, or a foreign debtor, whether it's an individual, an LLC, or a corporation, who is actively hiding assets from us, or who we reasonably believe is getting ready to engage in that conduct. So that's kind of the basis for seeking an attachment order. Claim and delivery, again, is a prejudgment ancillary proceeding that we file at the time we file the lawsuit. Claim and delivery we would typically use in a secured loan transaction situation. So if we have collateral securing our loan, personal property collateral securing our loan, be it fleet of vehicles, farm equipment, whatever it may be, machinery, equipment, we can pursue a claim and delivery order from the clerk of court at the outset of the case. It does require some additional legwork on the front end, a hearing in front of the clerk of court, service of some documents on the debtor with notice and the ability for them to participate in that hearing as well. And posting of a bond, and the bond amount is typically going to be 2 times the value of the property at the time of filing this proceeding. If we get that claim and delivery order issued by the clerk, which more often than not we do, that order goes to the sheriff and directs the sheriff to go out and take this property from the debtor prior to the entry of a judgment. So get it out of their hands so it can't disappear. Unlike a writ of possession where the sheriff does not have authority to breach the peace, if the debtor has the property under lock and key or tells them to get off their property, they can't do anything about it. With a claim and delivery order, the sheriff can tear the door off of a barn or tear down a fence and enter the property without their consent and permission to recover this property under that order. So it gives the creditor a much more aggressive ability to recover their property if the debtor's trying to hold it away from you. And then offset rights. Offset rights can be contractual. Offset rights can be common law. If you are a bank or a financial institution and you're pursuing a debtor who is in default and owes you money, and they have money on deposit with your institution as well, we can and should always consider and look at offset rights. And we may not always exercise offset rights. There are instances where the funds in the account are not shouldn't be offset, or it's a trust account, or some other type of account that we wouldn't have the ability to or wouldn't want to for reputational issues or otherwise offset. But that should always be a thought on our mind is, do I have the ability to offset? Can I offset? Should I offset? And we can help you walk through the relatively complex analysis of assessing those offset rights and pulling the trigger if that's an option on the table as well. And with that, I want to reserve the last few minutes here for Q&A, and I'll turn it back over to Haley.
Thanks so much, Tyler. So I'll go ahead and address this question that has come in. Let's see. If the married parties later divorce, does the lien of the judgment attach after the divorce? And if so, is the time for priority purposes and the date of the judgment or the date of the divorce?
Yes, I think this relates to the earlier conversation about judgment liens on real estate and when the lien attaches and doesn't attach. As Thomas mentioned before, so we have a thing called tenancy by the entireties in North Carolina, which doesn't exist in every state, but it does exist in North Carolina. And if a husband and wife or married couple take title to property during the marriage as husband and wife, and they don't otherwise state in the deed that they're acquiring title under a different ownership type, whether it be joint tenants with or without right of survivorship or tenancies in common or otherwise, the presumption is that they're acquiring title as tenants by the entireties. If they do acquire title and hold title as tenants by the entireties, our judgment lien would not attach unless both husband and wife are on the hook for the debt. And so if only one is on the hook during the course of a marriage, and assuming they do actually hold title as tenants by the entireties, which is not always the case. We always need to do that analysis and see if that is the case. Sometimes people will buy property together before they get married, as my wife and I did. And then if they don't go back and retitle the property in their names after the date of their marriage as husband and wife, then it's tenancy in common. It's not a tenancy by the entireties, and the judgment lien may attach to it, notwithstanding the fact that they're married today. So we always need to do that analysis. But if they did have the tenancy by the entireties at the time we obtained a judgment against either spouse A or spouse B, and later the marriage is dissolved, so does the tenancy by the entireties dissolve, and they become tenants in common unless they dispose of that property in some other way. North Carolina is also a race jurisdiction in terms of lien priorities. So first to file or perfect their lien typically stands first in line for repayment from an asset when it comes to liquidation preferences and liquidation order. And so having that lien on record earlier in time is always better than later in time. The date of divorce is going to have an impact on that analysis as well. But there's always going to be a factual kind of holistic analysis that has to be done of all of their other creditors as well, what they did with that property in the course of the lawsuit, or the equitable distribution piece of the divorce and things like that, which will impact whether or not the bank lien attaches. If so, what's its priority and right to repayment as opposed to others.
Great. Thank you, Tyler. We had one more come in. Any experience dealing with the UCC filings on solar panel companies have filled on house properties, which cloud the title, I think it said could the title as to getting to that asset without satisfying the UCC lien?
Yeah.
Thomas has seen some solar company stuff here recently, so I'll let him take first crack.
Yeah, Joel, your question is really relevant for the times. Solar companies, especially around here, we've been seeing some issues with, Pink Energy and whatever, Power Home Solar and those folks. But UCC filings, it is what it is. It's the same analysis that Tyler was talking about. It's a race to the courthouse state. First in time is first to be dealt with, and so it's not uncommon to see these UCC filed by these solar companies. I'd be more concerned with claims of lien being filed as mechanics liens for the work that was done on the house itself, which could pose a problem. But as far as a UCC goes, if the bank has a deed of trust on the property that predates that UCC, assuming it's not a purchase money security interest that would hop in front for some reason, it should be dealt with on its own, in accordance with the priority of the parties.
Yeah, and Joel, I'll just add on because I know we're short on time. It's kind of two issues there, right? When we're talking about clouding title with houses, and are we talking about real estate, or are we talking about personal property, or are we talking about fixtures? And fixtures may be part of your collateral if it's real estate collateral covered by a deed of trust, and if your deed of trust is first in line, then it is what it is, right? And the question becomes, what are we doing? What are we trying to do? What's the situation if we're talking about enforcing rights against the property following default? If we foreclose and there's no fixture filing, no proper fixture filing by that solar power company who's asserting a lien on those fixtures that has priority over your deed of trust, then foreclosure should wipe those interests out. We got to do title work. We got to investigate and kind of figure out whether or not that's the case. But I think that would be the general rule there. If we're talking about UCC filings perfecting liens on personal property, we may be getting into that fixture versus trade fixture analysis and fight that we haven't seen a whole lot of recently, but certainly used to see as a significant and common issue during the height of the Great Recession. And there's a whole factual analysis that we've got to go through and Q&A that we've got to go through to get a better handle on whether or not a piece of property that we want to recover from is in fact a fixture, which goes with the real estate, or a trade fixture, which does not. And UCC filings in and of themselves are just public record and public notice of a potential lien that may be out there. UCC filings do have to be filed timely and properly in order to perfect a lien on personal property in North Carolina. But just because there's a UCC filing on record doesn't mean that there's an actual security interest and security agreement between the two parties, which gives rise to a lien that the UCC perfects. So it can be a messy issue to deal through, and there's anytime you have that come up, there's going to be kind of a litany of Q&A and issue analysis that needs to be done to figure out if it actually does cloud title, if it's something that a title insurance company will insure over, or if we're going to have to go address it and try to pursue a court order to quiet title or some other activity in order to move to the next stop of our recovery process. And I know we're over time, and I don't see any other questions in the question and answer box. And so I suppose, Haley, we can end the call and release everybody to their day. And I just want to say thank you again to everyone who's on the call. We appreciate each of you as clients, as referral sources, as friends as well. And thank you for the trust that you put in us for educational concepts like this, and especially thank you for the trust that you put in us to help you and help your institutions with the significant and important legal issues that you encounter in the course of the day. And anything that Thomas, myself, or anyone else in our creditors' rights group can do, or otherwise at the firm to help you or help your institution, please feel free to reach out, and we're more than happy to have a follow-up call or conversation with you about it. So thank you again.
Thank you. Very well said, Tyler. And thank you to Thomas and Tyler for a wonderful webinar. For those of you in attendance, following this webinar, you'll be sent an email with a recording of the session. I can usually get that out by the end of the day or first thing tomorrow. Please save the date for our second installment. That'll be hosted by Paul Fanning and Lance Martin. And this will be on July 19th. I'll be sending out an email to register for this one in the upcoming days as well. We really appreciate you taking the time to join us. And like Tyler said, we hope that the information you learned today really applies to your business. So thank you. This is going to conclude today's webinar. Have a great day, everyone.